to people about our next one. Just going to give it a few more minutes for people to join in. People? Oops. Next one. Hold on. Give it a few more minutes for people to join in. Where's the... All right. We're live on YouTube as well. So that's good.
Do you want to check the chat to make sure people can? I think it's working.
Yeah, I was checking it before.
I think, it's for, yeah, there's someone messaged. Yes.
Yeah. Jim. Looks like Jim is having a good time there, talking to himself. I don't know if I should. I'll delete them. There you go. All right. While we're waiting for a few people to join in, those that are coming in and already here, can we please test it out that your chat bar is working as well? If you can please just message us where you're logging in from tonight, we'll most appreciate it. Just to get the feel of where people are in the world. I see some familiar names here, which is really cool. Oh, cool. Awesome. We've got Wellington, we've got Auckland. Wellington. Hi, Evan. Nice to see you. Hi, Natalia. Hi, Peter. Hopefully a few more people will join us soon as well.
And if any of you, I was going to say, if any of you guys have any questions in relation to relationship property law, property division, feel free to send them in the chat, because at the end, I guess it may take a while to type if it's a specific question. So feel free to send them anytime and we can have a look.
Yeah, I was going to talk them through the housekeeping. I'm just going to press the button, guys, to start recording the webinar, because there are some people that can't attend tonight and they've asked me to record the session and we can send them out the recording. So there we go. And we also live on YouTube. If anyone is struggling to come in, hopefully they can watch us through that platform. Awesome. While we're waiting for a few more people to join us in, would love to find out if you're currently, well, in a relationship, and whether you've had a relationship before where things didn't go well. You could put yes or no, whatever. You can message just to us. There's an option to message just to the host and panelists. If you don't want anyone else to see it, you can message just to us. And whether you are in a new relationship, and this is why you thought this will be an interesting session. Just really want to understand why the session has caught your attention and what do you wish to get out of it. So if you can just put it in the chat bar for us, why you're here tonight and what you're hoping to get out of it, that would be awesome. That would help us. And as Polina said, a couple of housekeeping rules. We've got Q&A button at the bottom. If you do want to ask a question, there is an option to do that as well. And in that Q&A button, you can ask anonymous questions as well. So if you feel like you don't want to share your identity with anyone, that question can be anonymous. Cool. I'm not sure, Polina, do you see the chat bar as well? Can you see the chat bar?
Yes.
Cool.
Yes.
Awesome. Great. Cool bananas. And There we go. We've got a few more people registering. It's just coming through now. For some reason. Okay, interesting. Thank you for your questions. Cool, keep them coming. All right, well, we'll kick in. Nice
And
one.
I see Leonie there, professional development. Hi, Leonie.
Yeah.
Leonie's another lawyer, so the pressure is on.
The pressure is on, Paulina. You've got another lawyer watching you. That's cool. Well, for those that don't know me, I assume most of you would know me because you did come from my mailing list. So I would assume most of you would know me here. However, there have been few from Paulina's mailing list. So maybe you don't know me. I'm Zibunisa. Oh, there you go. There's another professional development. I love it. You've got few there, Paulina, for your professional development.
Yeah.
I'm Zibunisa. I'm a mortgage advisor, financial advisor. I've been in the industry for over 15 years. I currently own my own franchise of Mike Piro Mortgages here in Wellington region. And it's been fantastic getting to know Paulina over the last few years. And we've run a couple of webinars in Russian. And we decided to bring you in English, the English version, because Paulina and I both speak Russian as well. And we were giving back a lot to our community. We love, love, love sharing the information and making it accessible for people without paying mega buck for, huge sessions. I mean, this session, Paulina would charge you probably a bomb to sit down with you and go through your relationship property agreements, but she's kindly offered her time to share some knowledge. Remember, this is not a financial advice. This is not legal advice. This is us sharing what we know. If you do need something specific to you, we would highly recommend booking time just with me or Paulina or both, etc., to go over your needs and what you need. So this is just a general overview of relationship law and asset division and the risk you may not be aware of. I've just pretty much read out your title, Paulina. This is the webinar. Now, in a couple of weeks' time, mark your calendars. In 2 weeks' time exact, we will be running another webinar with Paulina around trusts and wills. Wills? Yeah.
Yeah.
Why did I say trust? I think because I'm reading Jim's question at the same time. So the next webinar is in 2 weeks' time, and it's going to be around wills. So if you've got a will, come and watch. If you don't have a will, you should be really getting one, but come and watch our webinar in 2 weeks' time as well to understand why it's important to you. Oh, hi, Marina. Oh, thank you. That's lovely. Sorry, we're just getting some messages. Oh, no, that was to everyone, not to us. Okay, cool. All right. So without further ado, I will give Paulina the floor. But guys, keep your questions coming in the chat bar and we can have a look at everything that's here. Cool, Paulina, press your button. Let's go.
All right. And I'll leave you, Zibunisa, to interrupt and sort of, as you do, ask questions, because the questions you have, usually others have as well. So that's the way we've been doing it, to make it a bit more interactive.
Yeah.
Let me press slideshow. Where do I do that?
There you go. Play from the start. There was a button. Play. Yep, keep going. There you go.
There we go. Yeah. All right. So as everybody would already know, this webinar is on relationship and asset division. So basically, the question that I'm going to try to answer is what happens if your relationship breaks down and how you can protect yourself in division of assets. So about myself, a little bit about myself. I've been practicing law for 9 years, and I've specialized in this area from the beginning. At university, I think in my third year, I knew I wanted to do to specialize in trust, estates, and relationship property law. And I sort of structured my study around that. At that time, there was an international program came out in New Zealand that was called STEP, which is a Society of Trust and Estate Practitioners. It's a worldwide organization. And I enrolled into that instead of honors because I thought it would be more practical knowledge for me. And yeah, my love for this area of law sort of started there. And yeah, I went into law firm that specialized in that area and never looked back, basically. So I worked for 9 years, and last year I opened my own law firm, which obviously serves clients in those areas of law that I specialize in. So yeah, we advise, so VK Law advises clients on succession planning, wealth structuring, estate administration, elder law, and relationship property. Just a little bit of background about the firm. And as I mentioned, our expertise. Got Zibuniso there. So as you already know, Zibuniso is a mortgage broker, and she owns My Para franchise. She's the founder of that Home Loan Hub podcast. I'm very thankful for her for hosting this podcast that I think are very useful to people. I listen to her podcast myself and find a lot of the sessions, or most of them, are very, very interesting.
Thank you.
As you already mentioned, a little disclaimer, this is not legal advice, and obviously it's not possible to put all the information in the 30 minutes that we have. So it's just a summary of the law and what I think is most relevant to you, and sort of what we can pass on to you in 30 minutes. I'm just wondering why I can't see, oh, there it is. I can't see both the slides and a video. Can you still see the slideshow, Boniso?
Yeah, we were seeing
yeah?
it.
Oh, it's still, yeah. On. And now as well, yeah. Great.
Yeah, but
all
press
right.
the play from the start. Play from current. Wait.
Okay, that's yeah.
Okay.
Because then I can't see you. Feel like I'm talking
you don't
to
need
the
to
screen.
See. That's okay.
That's okay. I just feel like I'm talking to the screen. There's no one behind. Okay. So we'll start with what governs relationship property law in New Zealand. So that's the Property Relationships Act 1976. In short, it's called PRA, and I'll refer to it as PRA. So PRA distinguishes between relationship property and separate property. It applies to de facto relationships, marriages, and civil unions. Not many countries recognize de facto relationship in the way that New Zealand does, whereby it basically gives you mostly the same rights as if you were married. There are only a few exceptions in terms of how marriage is different from relationship property, from de facto relationship when it comes to division of assets, and that's to do with trusts. But generally, if you're in a de facto relationship, and I'll explain what that is, you have similar rights to if you were married when it comes to dividing your assets. So PRA sets out the procedure for division of assets in separations, and it also sets out the procedure for contracting out agreements, which is the prenups, which is an agreement you can sign if you do not want the default regime to apply to your relationship. So what is relationship property? So relationship property is property that gets divided half-half on separation or death. And the Act defines what that is. And it's listed here on the slide, which I will go over. So basically, it's family home. It doesn't matter when it was acquired, whether you had it prior to the relationship or you purchased it during the relationship. It doesn't matter whose name it's registered in, provided it's in the name of one of the partners, or who paid the deposit or who pays the mortgage. If it's a home where you live with your partner, in most circumstances, if you lived together for over 3 years, it would be divided half equally between you. Family chattels, so that's things that are in the house, like furniture, furniture, washing machines, things like cars that you use jointly, boats, etc., and so on. All property owned jointly, basically, if you have any other real estate that's registered to your joint names. Income, so income is a lot of people find that surprising. A lot of people don't actually know that all income that is earned during the relationship is shared equally. What that means is if you have any savings, so say you've been together for 10 years, you separate, you each accumulated savings from your salary, they would be shared equally between you. For some reason, a lot of people think, well, not for some reason, it's just lack of knowledge that if the salary gets paid into your personal bank account, it's not joint. It's still joint. Obviously, you can spend it as you please, but if you do separate, you would be providing disclosure if you do go through the process through the lawyers, and that would be shared equally. Proportion of the value of life insurance that's attributable to the relationship. So attributable to the relationship means that accumulated during your relationship. Same goes for the KiwiSaver. Again, what it means with KiwiSaver, same as your savings, you're not going to be splitting the balance from, when you started working when you were 18 to the separation, unless you were with your partner for that time. It would be just the balance that accumulated during the relationship. Property acquired prior to relationship, but in contemplation of relationship, is also caught as relationship property. And separate property that becomes relationship property, and that will make sense on the next slide. So basically, if you had separate property, or it had the status of the separate property, but then you intermingled that or mixed it with relationship property, or your partner somehow contributed to that separate property, it can also become relationship property.
So basically, just to summarize quickly, what you've just said is anything that you have right now could be split 50-50 on separation or death. So regardless if you think that you're keeping it separate or your partner's name is not on it, therefore it belongs to you, it may not be the case. Everything could be 50-50. Right?
Subject to some exceptions, that's right.
Subject to some exceptions. Awesome.
Yeah, that's right.
Yeah. Cool. Carry on.
Yeah. Okay, so the next is, what is separate property? All property of either spouse or partner that is not relationship property is separate property. That's very helpful definition for you there, and that's right from the Act. So basically, any property that is not relationship property is separate property. And then all property that is acquired out of separate property. So if you have anything that is separate, obviously, and then if you resell it and you buy something else, it will still be separate property. Any increase in value of the separate property, any income or gains derived from separate property will also be separate property. Let me make it a bit easier. So what that means is, if you enter into a relationship and say you have real estate that's registered in your name, you are not going to live there with your partner. The mortgage is fully paid, so you're not contributing any salary to it, any of your earnings. You get rent from it, but the rent is kept in a separate bank account. You don't apply that rent for your relationship. It's just there accumulating, for a bad day. That is your separate property. So if you keep it separate, you don't mix it in any way, it will most likely remain as your separate property. Now, if your partner, and that's section 9A there, if your partner starts contributing to that property by helping you to renovate it, it's usually the renovations. Or if there was a mortgage, it's disposition of salary. So both of you or one of you could be contributing salary there to pay the mortgage, because, for example, the rent is not enough to cover it. So that is disposing income to your separate asset, which can then change that status, if not of the whole property, but to an increase in value. So that means your partner may be entitled not to share in the whole property on the separation, but in the value that it has increased during your time together. Inheritance, actually, I should have mentioned on the slide. So inheritance is separate property. And if you keep it separate from the relationship, so you don't use it to buy a family home for you and your partner, or you don't buy a car for you and your partner, you just keep it separate. You invest it somewhere, in an asset that has nothing to do with your relationship, and you don't contribute to it financially, then it will most likely stay as your separate property. Now, de facto relationship. So as I mentioned, in New Zealand, the PRA applies to a de facto relationship. So you don't have to be married for the 50-50 split to apply. So what is a de facto relationship? It's a relationship where people live together as a couple for a period of 3 or more years, although it's possible for it to be shorter in some circumstances. Generally, a couple needs to live together to be presumed to be in a de facto relationship. But if a couple doesn't live together, other factors will determine if they're in de facto relationship.
So
What that means
Polina,
is, yeah. Mhm.
quick one, just a quick one to clarify. Basically, if a couple is together, they have to live together for at least 3 years or more, right? And as you say, sometimes it could be a shorter period. But
Mhm.
if what if they have like 2 houses and stuff and they live between the houses?
Yeah. So that could be de facto. So that's it doesn't. In most cases, people would be living together, and if they have 2 houses, they would still be sort of moving between one house to the other.
Mm.
But it's just one of the factors of the definition of de facto relationship, not not one factor. So it's possible for a couple to not live together and be in a de facto relationship, although it's just less likely. It does happen. You see that often with elder people who, perhaps lost a partner, and they found another partner, but they are, happy at their own homes, and they just need companionship, and they might not share finances as much between themselves, but there is that element, they might live, yes, you said, between 2 houses, and to an extent maybe share expenses. So it could potentially be a de facto relationship, especially if it's long enough. So usually the period when there's no living together factor, it's usually the length of the relationship that is, a factor you look for, how long the people actually been sort of in their companionship and to what extent they share. Or they have the other thing as a commitment to join life together. So that's the main thing. And a de facto relationship, you're supposed to have a commitment to join life together.
Thank you.
Yeah. Yeah, I've mentioned that already, that what surprises most people is that, if they live together in a relationship for, say, 5 or more years, equating the property occupied by them as their family home will be shared 50-50, notwithstanding who paid the deposit, who paid the largest share of the mortgage, or if only one of them is the registered owner. I did say 5 years here because if you've been together for just over 3 years, so between 3 to 4 years, there's an exception to that equal, the equal sharing, because you can argue that it's a relationship of short duration. And therefore, the division should be based on the contributions as opposed to, as opposed to 50-50. And that argument comes often. And look, if you see a relationship, a de facto, that's, people live together 3 to 4 years, one had a property prior to the relationship, or they purchased during the relationship, but one partner, say, paid 100,000 and the other paid nothing, 100,000 deposit, and the other paid nothing, maybe, but contributed to the mortgage. It is arguable that it should be shared on a contribution basis, because it's otherwise unfair and it's relationship of short duration. So it's quite common, that comes before lawyers often, and it's reasonably easy to argue. Yeah, pretty much that is a short summary of the main parts of the Act. And I thought the best way to work through that, or to explain this, is to work through some case studies, which cover the most common cases that, come before us when it comes to separation. And when I say common, I'm only talking about easy cases, everyday cases, not complex relationship property divisions. Do you have any questions there, Zibunisa, in terms of what I covered, or?
No, I think
No,
you've
good.
done a really good job explaining what the relationships are and what the in terms of de facto as well, because that's very important. Because sometimes people think that they have to be married in order to have that separation done, but no, in most cases, you don't have to be married. You can be in de facto relationship for the law to apply to you. So
And
that's
it's quite a distinguishing factor of our legislation because many countries don't have that. Most countries don't have that. Even England, you know, doesn't have it, but yeah, we do, which is a good and a bad thing sometimes. But yeah.
interesting.
Okay.
Okay, let's look at the
So
case
move on
study
to
you've
case
got.
studies. Yeah. Yeah.
So you've got Kate and Jack, and they've been married. Well, they've been in a relationship for 5 years. Looks like they've bought a house in 2023 where they live. Kate done a really good job. She's contributed
Mhm.
$100,000 to the purchase, while Jack was probably a bit busy studying, doing other stuff, and he contributed 15,000 to the purchase. And they both paid the mortgage as they went,
Mhm.
and Kate slightly more than Jack. They both have a car, a KiwiSaver savings. What could possibly go wrong? They've separated 5 years after being together. What's going to happen to them, Paulina? How are they going to divide their assets?
All right. So both are, in this case, both are entitled to share equally in the family home. That's because they've been together over 5 years and they didn't sign a prenuptial agreement, so a prenup. Notwithstanding that Kate contributed significantly more, the equal sharing regime will apply to them unless Kate can argue, that it's a relationship of short duration, which will be a bit hard for her because it's 5 years. So it's a bit, it's not between 3 to 4, 5, although that's still possible, but it would be quite a hard argument for her. So, for example, if the value of the family home is 1.5 million and mortgage is 1.35 million, each will get 75,000. So obviously that's base value of the home minus the outstanding mortgage, and then the equity gets split equally. So in terms of KiwiSaver, Jack KiwiSaver is 30,000 and Kate's 15. So there's a difference of 15,000. So Jack will be liable for an adjustment to Kate for the difference. So the difference is 15,000. So to put them in equal position, Jack has to pay Kate 7,500. And the bank accounts will be dealt in the same way. So if there's a difference of funds accumulated during the relationship, there will also be an adjustment in a similar way as in KiwiSaver with the KiwiSaver. Kate's car is 5,000. It's 5,000 more expensive than Jack's. She will have to pay him 2,500 for the difference in value to retain her car and for him to retain his car. So the way this is calculated in relationship in division of assets is usually if it's done through lawyers, which normally it is when real estate is involved. The figures will be all put together and there will be, a spreadsheet. So Jack won't actually have to withdraw his KiwiSaver to pay Kate. It will be worked out together with the 75,000 that each of them gets from the family home sale if they were to sell it. So the remaining figures will be taken into account. So for example, Jack will get not 75,000, but a bit less because he has to pay an adjustment to Kate for the difference in the KiwiSaver. But then similarly, Kate's adjustment of 2,500 will also be taken into account. So it will all be calculated together. So KiwiSaver actually stays as is. It is quite a common question because people think you actually have to do something with your KiwiSaver when you separate and one person has more in KiwiSaver than the other. Normally you don't. So in most cases, if there is enough money to equalize everything, you don't actually need to touch your KiwiSaver. It's only in extraordinary circumstances where you need to do something with your KiwiSaver or withdraw it to pay the other party, and there's a specific provision in the act that allows to make an application to allow for that withdrawal through court.
Yeah, this is a very fantastic way. Can you just go back a step for
Yeah.
a minute?
Mm-hmm.
This is a really good example of how one person could be disadvantaged if they haven't got the right agreement in place. Because, for instance, in Kate's case, she contributed $100,000 towards this purchase price, and she's walking away. If they were to sell the house today, she's walking away with only 75,000. And even after the adjustment, Jack may owe her $5,000 more. Okay, fine, 80,000. But she put forward 100. So she's walking away with a loss. And during that time, she also paid for that mortgage, and probably the property gone up in value or gone down in value, regardless. She's just lost $20,000. While Jack, he only contributed $15,000 towards this purchase price. He's benefited from living in a good place, and now he's suddenly walking away. So his money quadrupled in the time that he's been together with Kate after buying this house. So he's, I think, put on 15,000 in the beginning, and now he's got 70K to walk away with. So as you can see, this is where people go, oh, that's not fair, and then they go and try to battle it out. But the law is a law, and it's really hard sometimes to battle out. So if you don't have the right relationship property agreement in place, this is where you could get caught out quite easily. Awesome.
Yeah, that's right. Yeah, necessarily that there is a potential to argue the short duration in this case, but in cases where there are kids, that's harder because you can't, even if it's short duration where the kids involved, and becomes more complicated. So less chances of success in that. All right, next one. So in this case, Ben and Sarah have been in a relationship for 7 years. Since 2018. They have always lived in a rental accommodation. But in 2021, Ben's parents gave him 100K, which he used as a deposit to purchase an investment property in Hamilton for $1 million. Although the property has been tenanted since, the rent does not cover the mortgage fully, and Ben has been contributing around $300 weekly from his salary to cover that shortfall to pay the mortgage. The parties separated in 2025, so 7 years later. And in 2025, so today the Hamilton property is worth $1.4 million. So it has increased in value by 400,000, which is unlikely, but imaginary scenario, wishful thinking. Sarah thinks she has an entitlement to a share of Hamilton property.
Can I just pause you there for a second before you give us an answer? Let's just turn to our audience and think and ask them, what do you guys think Sarah will have out of the separation? Is she entitled to the share of Hamilton property, in your opinion? Just a bit of fun, just to see. Just make sure people are listening to us, Polina. Getting the audience engaged. What do you guys think? Oh, come back. Come back. Come back.
Hi.
Love it.
So my skills.
What do you guys think? Okay, yes, as he was contributing his income, which was earned during the relationship. Yes, because the $300 weekly is shared property. Okay, some good answers here. Awesome. Anyone else? Yes, because of the money being paid during relationship. But Sarah didn't contribute to it, did she? It was him. It was mainly him contributing. And it was his parents that gave him the money. Guess she's eligible. Okay, all right. Paulina, tell us. Tell us what's happened.
So Sarah will likely be entitled to share in the increase in value of the property. So it won't be the full value of the property, which would be obviously very, very unfair, which is, if they had shared the whole 1.4 million. But she may have an entitlement to share in the increase in value of the property. And that will be because of Ben's contribution from his salary towards the property. Because remember that salary is relationship property. So what could Ben have done better? He could have entered into a prenup. Prenup is also known as a contracting out agreement or Section 21 agreement. Those are the three main terms used for this type of agreement. So he could have signed it with Sarah prior to the relationship or during the relationship, as soon as his parents decided to give him such a big amount of money to purchase a property. And in that agreement, they could have agreed that notwithstanding that he will be putting some money there from his salary, she would not have any entitlement to it. But since that wasn't done, Sarah is likely to have a claim, to that property. And what may happen is they may negotiate a settlement that they think is fair, because that often happens. Because sometimes people still think, it's unfair, that Sarah. Well, the couples sometimes think between themselves. Even the one who is claiming that it's unfair to share 50% in the increase in value to get 50% of that, and they might obviously between themselves come to a different agreement. But if she was going fall into this and, wanted her 50% of the increase in value, she'd likely succeed.
That's
So I
incredible.
guess everybody guessed that answer. Yeah.
Yeah,
Vanessa, you read? Yeah.
they did really well. They were listening to you. That's awesome. Yeah. So as you can see, guys, in this position, Ben is the one that got a little bit disadvantaged. But yeah, unfortunately, when you're in a relationship, everything's 50-50. And just to answer to the previous one, I think you did answer Marina's question there, that even if the relationship is short, but because you've got a child, the 50-50 rule applies. So yes,
I can't see the questions. I'll have a look at them once I finish, but only because my slides are. But if
but
we can come back and
yeah,
there
that was
a related
funny.
question.
Yeah, you did answer as she typed it, so it was.
Oh, right.
It was amazing. Okay, awesome. Keep going. Thank you.
Oh, I've covered that. So yeah, how could Kate and Ben have protected their interests? So as I mentioned, contracting out agreement, also known as prenup or Section 21. Few points there that Section 21 agreement can generally be entered at any point during the relationship, but the earlier the better. That's because once the entitlement is there, so after 3 years, one of the parties already entitled, there are more obligations on the lawyers who certify the agreement. So that leads to higher legal costs. That means you have to provide disclosure to each other through your lawyers. So actually disclosing how much you have in your bank accounts and your KiwiSaver, because the lawyer can't advise if the agreement is fair and what's the other parties giving up without knowing that. Best practice is to provide disclosure regardless when you enter into the agreement, but if it's after the 3 years, then it has to be provided. Section 21 agreement requires each party to have his or her own lawyer, provide disclosure of assets mentioned, and lawyers have to certify the agreement. So it's not about the party signing. The lawyer actually has to certify the agreement. And I think I saw there was a question from someone on that. If the agreement hasn't been signed and certified by a lawyer, it's not binding. So just because you had it drafted, it's not going to do anything for you unless the other party just agrees to go with it. But because to be binding, it has to be certified by both lawyers, by lawyer for each party. Right. Moving on to some exciting things. Contracting, so the cost of a contracting out agreement.
You should have done a quiz on that. How much do people think it costs before moving on to this one?
And it varies, right, in different cities. I think it's a little bit slightly, although as far as somewhere, it's kind of maybe across the board. But yeah, I think somewhere in South Island, Dunedin might be cheaper than it would be in Auckland, for example. So yeah, anywhere from 2,000 to 15 to 20,000 and more. 2,000 to 2,500 plus GST being a reasonably simple agreement. So something like recording the rights in respect of family home where the deposits are unequal. So for example, party A contributed 200,000, party B contributes 100, and party A wants to make sure that if they do separate, party A gets his or her 200,000, and the other party gets 100,000 before they split everything, the remaining equally. And the agreement doesn't touch anything else. Everything else will be by the default, whatever the law says that will apply. So that's reasonably simple. or when parties being already at in their say 50s and they already accumulated assets. They're not planning to have children together. They're just now at the stage of life where each is comfortable and want to protect their assets as separate. They don't want to share anything ever, because they have kids from previous relationships and they want to protect the assets from them. So that's reasonably simple too, because there are no risks to lawyers involved. It all makes sense. No one is giving up something that rights that that a lawyer can consider unfair. And then there is, I probably should mention, 2,500 to 5. That's when you have trusts involved. So obviously, a lot of parties in New Zealand, specifically, a country that loves trusts. A lot of families, couples have trusts. When trusts are involved, trust ownership, it complicates the agreements. It becomes way longer. It just becomes more complicated. The additional considerations, provisions that need to be included, and that increases the cost. And 10,000 plus being complex agreements where significant wealth is involved. I've worked on cases, significant number of cases where by the end of the matter, total cost would be 20,000 plus. This usually involve complicated matters, basically very complicated, significant wealth, and most cost relates to negotiation. So it's not actually drafting the agreement. Most of the time it would be negotiation, because one might be earning a lot and the other doesn't. And they are negotiating not just how they want things to be right now, but how they want things to be in 5 years' time, in 10 years' time, or when they have one child, or when they have 5 kids, because those agreements, they don't need to be just about now. They can be about what happens in 10, 15 years. And that's because a lot of people don't want to come back to it, so they actually want to think through all stages, or through foreseeable future, and agree on things.
Yeah, and that's important, isn't it, for people to understand that the cost up front may look scary, and they don't want to spend $2,000 right now. But then when the separations do happen, people end up spending way more than that on lawyers and on negotiations, and then losing out more in assets. So definitely, if you're in a new relationship, be more prepared upfront, especially if you already had burns in the past. Definitely be more prepared going forward.
And things like with contracting, because a lot of people look at contracting out agreements as something that's, if one person is asked, if one of the partners is asked to sign a prenup, some people think it's a bad thing, like, oh, I've been asked to sign a prenup. But I always say it's not necessarily a bad thing, unless you've been given with something that is so horrible, so unfair. But in most cases, the prenup can be a good thing, because especially if there are trust involved. Say you're coming into a relationship with someone who's got a lot of trust structures, the property, everything is in trusts. You actually don't know where you stand in terms of, if you separate, what's going to happen. And even worse, if the person dies and you were together until he or she died, but then he or she had children, adult children, for example. And then you have to fight with that person's children over your entitlement, because your entitlement would not necessarily be clear, or it may be clear to your lawyer, but the other lawyer might disagree, because when it comes to trust structures and relationship property, it becomes very complicated. Sometimes there is no one answer that's 100% right. It's about who argues it better, or who has more money to keep going for longer, or to go to court. So in those cases, it's better to consider having a prenup, so you know where you stand. Maybe you will get a bit less than if you went to court, but at least should that relationship end, you're going to walk out with it without having to spend your energy and finances on fighting. And yeah, there were situations when a partner dies and you were in love, you were together, he wanted to leave you something, or he or she, and just didn't get to it because didn't know he or she was going to die. and there you are, in a fight with his estate, where might be children, and yeah, things just go horribly wrong in those situations. Okay, and so related on this is briefly on the separation process. So separation, a lot of people do just separate, never see a lawyer, particularly if they don't have real estate. They just split the asset. They might not even, consider splitting their KiwiSavers or savings. They just walk out with whatever each has in a bank account, and they're happy. They're happy. They didn't need a lawyer. They didn't need to spend money. But most people do end up going to lawyers because they have real estate, or sometimes they have kids. They can't agree on custody, and then they also start talking about assets, and they end up basically sorting everything via their lawyers. So separation agreements follow the same process as Section 21 agreement as prenup. So they need to be certified by two lawyers, one lawyer acting for each party. Otherwise, they are not legally binding. So if you write up a paper, we agreed on this, but you didn't have a lawyer acting for each of you that certified that agreement and advised you on it, it's not legally binding. When you do work with lawyers on separation, on division of assets, disclosure is involved as well. So as I mentioned before, each of you would have to advise your lawyer what you own. For people who've been together for 30 years, in most cases, their assets are all joint. So, there's nothing to hide. They have joint accounts, joint house in the joint name. So easy. But for those who have assets in personal names, bank accounts where salaries goes, KiwiSavers, cars. So you have to advise your lawyer, provide statement of how much you have in your accounts, in your KiwiSaver as at the date of separation, and as at the date when your relationship started, for the lawyer, for you to figure out what balance is attributable to the relationship and therefore is up for the split. So agreements must be fair. The general guidance being that, relationship property shared 50-50, and any departure is carefully scrutinized by lawyers. There is all not disagreement. All lawyers are different in terms of the risk they want to tolerate. Some might not even agree to sign an agreement that is very unfair, right? Where the lawyer says it should be 50-50, but one party is retaining 80 and the other 20. If a lawyer is not happy with taking the risk of that agreement ever being, applied to be overturned by court. So, where one party after 3 years changes their mind and says, I didn't get proper advice, I'm going to apply to the court and try to reverse this outcome. So, yeah, some lawyers might not certify that, some will happily certify. So, so that varies. Something that people should be able to agree to whatever they want, provided that they had proper advice. Yeah, so I've mentioned, so the last paragraph there is that, lawyers can refuse to certify it if it's grossly unjust because very high risk. So some don't want to run the risk of being sued for certifying an agreement that is very unjust. And some lawyers just don't want to have that reputation of having the judge to overturn the agreement that was certified by him or her. So some suggestions. What can you do if you want to protect your assets? If you have separate assets you want to protect, or if you starting a relationship, and you're purchasing a real estate, for example, and putting your savings towards that asset, and your contribution might be way higher than your partner's. So what can you do? As mentioned, you should consider prenup early in the relationship because it's just easier to work through it for lawyers. That's one thing. The other thing being is it's emotionally easier for couples. Or at least that's what I find, and what many lawyers would find is it's an easier conversation to approach when you're in early stages of the relationship, as opposed to when you're already 5 or 10 years into relationship, you might have kids. It's just become a harder conversation. And some people actually don't bring it, or they want to bring it up, but they don't bring it up just because they're afraid that this might, break down the relationship. Look for a specialist relationship property lawyer, especially if the agreement is, not the most simplest. It may mean that you might pay a little bit more, 2,500 instead of 1.5, but it's better than having that exposure, that risk that, in 10 years' time, one of the partners might decide that they actually don't want this agreement anymore. They want more, and they apply to the court and try to get it overturned, which is very hard to do. It's not an easy thing to do, and it's not a cheap thing to do, but it is possible, and it happens more often than you think, especially in agreements that are, high stake. But yeah, relationship property is very specialized area, and sometimes, things do go wrong with when they're handled by people who don't know a lot about it. If you have children from a previous relationship, make sure to get legal advice to ensure you protect your interest. And again, you should do that as early as possible when you enter into a new relationship. If on separation you are keeping significantly more than your partner because you agreed to that, make sure you go through the separation agreement process. Otherwise, your partner can change their mind and come back for more. It's not worth the risk, basically. A lot of people do that. They amicably agree. One retains 70%, or because, for example, one paid a higher deposit and they agree it's fair that the person who paid more for the deposit should retain that, and they part ways. And in most cases, that's it. But sometimes, one party might change their mind, and 3 years later, knock your door and say, "I want more." And if you didn't have the separation agreement, they will be entitled to it. If you purchase property together, discuss with your lawyer whether it's appropriate to own the property jointly or as tenants in common. And if you're not sure, choose tenants in common. So I'll touch on that because that's something a lot of people don't know. I don't understand that the difference is quite significant. So jointly owned property is when you own the property together as sort of one undivided share. So what that means is that it passes to the survivor outside of probate process. So it's outside of your will. So for example, in your will, you might leave all your assets to your children from your first relationship, from your first marriage. But you purchased a home with your new partner and you registered as joint owners. If you die, your partner will get that property automatically. Your partner wouldn't even need to wait for probate of your will because joint ownership means that it passes by law outside of probate. So it's an automatic right. It is just a matter of going to a lawyer, signing a declaration that you're entitled to it and that you are you and that this person died, and it will be transferred to your name. It wasn't still commonly used for people who together, who married because they don't want to bother with the probate process with the will. They just wanted to pass to the other. But it may not always be appropriate for your circumstances. Like the example I gave with the children. Sometimes people, they in their will, they might actually want to leave all their assets, say, to children, or the share in the house to the children. But they might not realize that it's owned jointly, and it means it's not even part of your will. And where things go wrong is, and something I will be touching on a lot in the next webinar, but it's when you do things like an online will, which is not where you do a title search. So when you go to a lawyer and you do a will, a lawyer will do title search and make sure, check what you own, what properties you own, how you own it, whether jointly or as a tenants in common. If you do an online will, that's not something that's done. So you might think your assets are going to this person, but actually they will be passing to the person, who's registered on the title with you. So if you're not sure, choose tenants in common. Tenants in common, that's being half share each, or or more, or 75%, 25%, whatever you choose. But it basically means you own it in shares that you agree to own it. And
Awesome.
yeah, and
Thank you.
that's it.
Thanks, Paulina. I think we've zoomed through it, but you've made it so simple to
What
understand.
time? Oh, yeah, it's already 8:50. So
Yeah, you
I
did
thought it was
really
30
well.
minutes. Quite long.
No. I think you did really well. And let's address some questions. There was a really cute question asking if it's a recorded webinar that we're presenting right now. No, Christina, this webinar is live. We are live. We are sitting here 8 o'clock at night, almost 9 in New Zealand. Paulina is in Auckland and I'm in Waikanae. So it is a live webinar. So if you do have any questions, please feel free to ask them. We will address them. There's a question button or a chat button. So we're going to hang around for the next few minutes, 5 to 10 minutes, 10 minutes, maybe more. So please get your questions coming. I think what you've covered, Paulina, is really, really important because a lot of people these days tend to separate. I mean, the statistics are crazy of divorces and separations. So this is important. And a lot of people do go into their second relationships and third relationships as well. And if you're not protecting your assets, it can get expensive very fast. And you can find yourself very asset poor by the time you come to your retirement age, and you don't want to be in that position. You want to make sure whatever you're working hard for is protected. I think
Right.
that's the key
Yeah.
takeaway, really. Yeah. Guys, do you have any questions for us? Let's address some that are there. So do you want to stop sharing your screen, and then that way you can see the chat bar? If you stop at the thing, there you go.
Yes.
If we go to the chat bar, one of the questions was in the beginning, I have had a property relationship agreement drawn up, and for the last 8 years, I got busy and I didn't get legal advice on my end. Signed. So it hasn't been signed, by the look of it. Is that still enforceable through the court? So there was a relationship property agreement drawn up.
But it wasn't signed. Yeah. I kind of mentioned. So it's not enforceable. And yes, even if you go to court, it's not enforceable. So it's not binding. Yeah, unfortunately. Sorry. I wish I could have better news.
Should have gone to a lawyer 8 years ago.
Yeah.
What would love to find out is what have been the takeaways for you guys. I know in the beginning you've mentioned why you're here, but if some of you would like to share what has been the takeaway for you, would really appreciate the feedback from you. All right, let's see what else was there. Okay. Is it true that even if the relationship is one of oh no, we've covered that one, short duration with the kids. We've got that one. There was another one.
What about a trust? Is it better on
The
that?
trust. Oh, there we go. Is it better to purchase my new house under trust to protect myself?
So assuming that you're going into a new relationship and you're thinking if you should put the house in a trust to protect yourself, yes, a trust is always better than no trust and no prenup, but prenup is better than a trust. Does that make sense to you, Sibonisa? If it does to you, Shivek, yeah?
Yeah, so if you are to choose one or the other, do a prenup.
Choose a prenup, yes. But if you're not going to do the prenup, then trust is better than nothing. Yeah. And that's because some people just don't want to do a prenup because they're afraid that might affect their relationship with their partner, or one partner just refuses to sign it. But if you are not in a relationship yet, so it's better to put a property into a trust way before you enter the relationship. So it can be argued that you put the property in a trust in contemplation of your relationship because you wanted to hide it from your new partner. So do it before you enter the relationship. Don't wait to be in a relationship. And then, there are many other considerations like, well, is there going to be a mortgage? If there's a mortgage, are you going to be putting your salary into the trust? Because if you are putting the salary into the trust, you are disposing of relationship property, which means your partner would have an entitlement to it. So, they might have a harder time arguing about it, but they will still have a solid argument. So, as I said, yeah, prenup is always better. But trust can protect you from or provide you. You might have succession planning needs in terms of, you might have children from previous relationships. So, if you're not just talking about protecting from a partner, there might be other reasons why trust is a great idea for you to do. Yeah.
Thank you. There's another question from Evan. If a couple starts seeing each other for 2 years and then they live together for 1 year, are they in a de facto relationship as they've been together for 3 years, or do they have to live together for 3 years? So they've been just seeing each other for 2 and then only live together 1.
Yeah, so it's about living together. So your de facto relationships actually starts from the time you qualify. So if in this example you're living together, so yeah, it will be from the time you start living together, unless one successfully argues that it started earlier because although you weren't living together, you had such a degree of commitment to mutual life, like basically ticked all other boxes except for living together, and they succeed in that argument, which is unlikely and doesn't really come up often. So yeah, so the practical short answer is that, yeah, it's from the time you start living together.
Okay. We've got a request to show the slide again with information about us. This person wants to buy an investment property soon, and they need some help, maybe. I'm not sure if they need my help or they need your help, maybe both of our helps. Thank you, Christina. If you would like to, you would have probably got an email from me with the Zoom. It's got some of my details. Maybe reach out to me and I'll send you information about me and Paulina. That would be great. That'll be easier because Paulina didn't really have our contacts on her slide. She just had our lovely
Yeah.
pictures.
I mean, yeah, my website is there, so it's just a matter if you can Google, yeah, PK Law, it will all come up. And for Zibonisa, yes, if people Google your name, everything will come up as well. But you can just send an email as well. Yeah, just feel free to reach out through the website. There's my
Thank you.
email there.
Thank you, Christina. It was really funny today, Paulina, before I came to the webinar tonight, I quickly popped out to this quiz night. It was a quiz night prize giving for Capity Cycle Club. And one of my new guys, James, he's a pro cycler. So he took me along as his +1 and we arrived there. And this guy came up to us and, just to say hi, we were in the queue and I said, hi. All I said was hi. And he turned around, he goes, I know this voice. And then he looked at me, he goes, Yuzi Boniso, I hear you on the radio all the time. So I thought that was really cute that people know me around
Recognize your
here.
voice.
Yeah, recognize my voice. There you go. Apparently I've got a very distinctive hi. Hi.
Hi.
Hi. Awesome. Thank you, guys. Any other questions? Look, we've got really cool feedback here. That was a really comprehensive overview, Paulina, really helpful. Thank you. You made an interesting point about tenants in common versus joint tenants when buying property in your relationship. So thank you. It was very informative. Marina made lots of notes. Thank you so much. Thank you, Natalia. Lots of useful info. Awesome. Thank you, Evan. Lovely to see you again. So cool when I see familiar names after a while. It's good. Guys, keep an eye out. We've got a next webinar coming up in 2 weeks' time, 8 o'clock. And Paulina and I will cover all about wills. And one more question. Okay, there's one more question. If, for example, one owns a house which was purchased before the relationship and the other has a child from previous relationship. So one has a house, one has a relationship, kid.
A child.
A child, yeah. When the relationship starts, the partner moves into the property. Then if one dies, what a child from a previous relationship will be entitled to? Okay. So when the relationship starts, the partner moves into the property. Who moves to where? The one with the child moves into the one with the house, I think.
I think that makes sense. Yeah, so the one that doesn't have a house moves into with the partner who has a house.
Yeah.
And assuming that they live together for long enough to be in a de facto relationship. And then the person who has a child, the partner who has a child, dies. So it won't be about the child, it will be about the partner who dies. So it will be up to his or her of the deceased estate to bring a claim against the partner who is living with the property. So to bring a relationship property claim. So basically, the deceased might be entitled to half of their house because it was occupied as a family home and they were in a de facto relationship. The deceased is no longer there to bring that claim for himself or herself. So the estate can step into its shoes because the estate becomes basically the deceased and bring that claim. So, for example, if the child, a daughter says 20, if she knows about it, she consulted, she can step into, as executor, for example, of the estate, assuming, or ask the executors to bring that claim against the surviving partner for 50% of the relationship property split. So yes, so potentially the property is up for grabs by the estate of the deceased. Yeah. Or not the property, half of the property.
Thank you,
And
Polina.
that happens often too. Yeah. So
Yeah. Wow, Karen. Yeah, maybe a good idea. So Karen says that maybe she'll keep her property in the trust.
yeah, it's trust in the situation where, especially if mortgage is paid off, and you're not, or you might still be paying the mortgage, but you accumulated, a large percentage of the equity in the property already. The trust would provide you protection. So you would definitely be better off than not having a trust at that stage of your life. All that comes with extra cost. In many cases, it's worth keeping.
Cool. Awesome. Thank you so much, Polina. Thank you so much for your time. I think it's a very, very important webinar, and we'll have the recording available for those that have missed it, so I can share that with you and you can send it out to your database.
Thank you.
Of people. So thank you. Appreciate your time. And I guess if there are no more questions that people have, we will wrap this up and I'll see you in 2 weeks' time, maybe in Auckland. Maybe I can come to your house and we can do it from your house
We
together.
could. Yeah, we can. Yeah, absolutely. We can
Sounds
go for
good.
a drink after.
Actually,
Yes.
yeah, webinar, drink, webinar, before the webinar, after the webinar.
Yeah, probably one before, one after, or more than one after. But
Yes,
thank you everyone for feedback. It's very nice, and if it's useful to someone, that's great. And because it's live and it stays there, so people watch as they need. So that's great.
Thank you. Awesome. Take care. Have a good
All
night.
right. Good night, everybody.
Thank you. Thank you, Marina, as well, for all the questions. This has